Hi, welcome to Judica County. My name is Ashley Penner, and I am an attorney with Whitaker Hamer. I also have attorneys Cassandra Nicholas and Jordan Mackey here joining me today, and we are going to talk about deeds, specifically quitclaim deeds. So, what is a quitclaim deed?
So, this is an instance where it's not a conveyance of property where you're warranting the title that you're passing in any way. It's just that someone's name is on the property or they have title to that property and they are relinquishing their rights to another. In our instance for us, it's not where money exchanges hands or anything like that. It's just some people's names on the property that no longer want to be on that property or for other reasons want to give the property to someone else. That's when the quitclaim deed is used to accomplish that.
And in addition to that, the person they could relinquish just some of their rights by adding someone onto the property with them as well.
Absolutely, yes, yep.
When do you most often see clients wanting to use a quitclaim deed for a matter?
So most often for me is mom and dad both pass away, brother and sister inherit the property, brother owns enough land, doesn't want anything to do with the property and wants to just quitclaim it over to his sister so the sister can own the property solely. That's probably around 90% of the ones I run into.
The ones I run into are more often situations where someone bought a property when they were a single person and they have later gotten married and want to add their spouse to the deed.
Absolutely. So the deed can be used to take someone off or put someone on.
Yep.
We typically require consultation for these. What would be discussed in this consultation regarding a quitclaim deed?
So I usually will ask for some property information. So if you can provide a tax bill for the property, that's always a great starting point. If you have access to the deed, that's also another great starting point. But it's not a necessity because we can always find those online. Usually from there, I just kind of will ask brief questions about understanding the situation and why this is taking place. So was the property inherited? It was a situation where a person got the property as a single person and now adding someone else to the property. The reason I do that is just to kind of make sure there's no red flags that pop up or anything that I think might not allow this to happen or may cause an issue for the person in the future by doing this quitclaim deed and getting it on record.
Along those lines, although we're not doing title work, I do ask questions about whether there are any current liens or mortgages on the property, especially if someone is being added to the deed that is not on a mortgage. That's important because it could trigger an acceleration clause in the owner's current mortgage, which would require the payment of their entire mortgage at once, which they don't want to do. So I want to make sure that that's not a problem we are causing for our clients.
And with heir property, a lot of times what I'll ask too is just for an idea of the family makeup. Maybe who could have inherited this property, whether there was a will when the property owner passed away that maybe controls who that property is now owned by, just so that I can understand fully what they're wanting to get done. And I can give them a little information about not whether title is going to pass fully, because we're not going to make any certifications towards title, but whether this is probably the right direction they want to go in and who needs to quitclaim the property over to them.
So let's say someone calls in and they want to quitclaim property to someone versus someone calling in saying that they've been in conversation with someone else that owns property and that individual is talking about quitclaiming the property to them. What are the differences in those consultations coming from the quitclaimer to the quitclaimee?
Yep, so one big one is if you are contacting us because someone is going to be quitclaiming the property to you, one good thing to always make sure of is that they understand what they are doing and they have agreed to do this. Because we're not going to work in negotiating for them to sign for it in any way. So they need to be willing to sign this deed in front of a notary for this to work. So that's always a good thing to kind of make sure of before we're talking about this and getting everything started. Versus what happens if you're the one trying to quitclaim the property to someone. What usually you'll want to make sure in that instance is that they are willing to take the property also. You don't want to quitclaim the property to someone that's not willing to accept delivery of that deed or that property in essence to themselves.
I do, on both sides of the equation, always mention to people that they should check with a CPA as well. We aren't qualified to give any tax advice, so I just want people to be aware that there may be potential tax implications of giving or receiving property. So I want them to check with someone who's qualified to advise them on those matters as well.
And if it's an elder person getting the property out of their name, it's always good to just kind of ask some elder planning questions along those lines, or if you don't have access at that time, to send them to someone who may be able to answer these questions about how this may affect any kind of Medicaid issues or things along those lines.
So it sounds like, again, there certainly could be a lot of ripples from signing what seems a simple and straightforward legal instrument. What types of representations are you making? I know you touched on this earlier, Jordan. So no title search has been performed, no tax certification is being made. What does the person who receives this deed get?
So in essence, what they are receiving is a document that is stating, and it's a legal record that's being recorded in the county where the property is located. And it states that whatever interest the person owned in that property, that is the grantor on the deed, it's whatever interest that is being relinquished over to the person who is the grantee on the deed. Whether that be the full interest they own at that time, or like we were talking earlier, it could be a partial interest being quitclaimed to someone. But really all it is that that person's interest, whatever that interest may be, is being passed to that person based on kind of what the language is, if it's lessened in any amount.
And if they say there's a mortgage against the property, they get the property and now they have a mortgage?
So in this case, the property is being conveyed subject to the mortgage. So their ownership of the property is subject to that mortgage being paid. So it's not their personal responsibility to be paying that mortgage unless they're on the mortgage also. But for them to enjoy the full rights of the property, they will need to pay that, make sure that mortgage is paid somehow.
So without a title search, you really don't know what you're getting if someone's quitclaiming property to you, is what I'm taking away.
In a lot of instances, yes. Unless you understand the situation fully, then you're kind of going in a little blindly to it.
But that is the importance of the
Yes.
consultation and us asking those questions to prompt people to explore and understand the situation that they're getting themselves into. And hopefully if you are using a quitclaim deed to either relinquish rights or gain rights, you trust the person that you're interacting with and do understand what you're receiving.
So I've had my deed prepared, and now what?
So it really depends on who's signing the deed, because it just needs to be signed at that point in front of a notary in the state in which it is signed. So we can mail the deeds out to people. We can email them out to people. We can have them sign in any of our offices. I've seen people sign in nursing homes. I mean, wherever a notary can be present, the deed can be signed. Once it's signed, the original, though, needs to be sent back to our office so that we can make sure it's put on record. And it needs to be the original. A lot of times what we will ask is that you scan in and send us a copy of it before mailing the original to us so we can make sure that it's correct. There's no notary issues, because that could delay the process of getting it recorded. But we do ask that you do mail us eventually the original so that we can get it on record, because that is a necessity for getting it on record.
My understanding is it's only good within 2 years. If it's not recorded within 2 years, then it's no good.
Yes. The statute touches on gift deeds or quitclaim deeds. Yes, having a 2 year from the date they're signed and needing to be recorded. So definitely do not want to wait 2 years before sending it back to us to get it on record.
Absolutely. Well, thank you both so much. This has been really informative. Thank you for tuning in today. If you have any questions about quitclaim deeds or any other kinds of deeds, please don't hesitate to call our office at 919-772-7000, or you can visit our website at wh.lawyer.